Property disclosures. The Real Estate Professional's Guide to Reducing Risk. Page 5. Amato versus Rathburn Realty Incorporated. 98 New Mexico 231647 P2D 433 NMCT APP 1982. In this case, the broker was held liable where he made incorrect representations about property and its income producing potential. The court ruled that the broker had the duty to exercise reasonable care in obtaining or communicating information and noted that a broker is a fiduciary in a position of great trust and confidence and must exercise the utmost good faith. Govia versus Citicorp Person to Person Financial Center Incorporated, New Mexico APP 1984. The court ruled that the broker had the duty to disclose known or discoverable defects, and his duty of care could also include duty to discover and disclose defects. The listing agent had described the property as all top shape, when in fact it was replete with major defects which were not apparent until the buyers moved in. The buyers alleged that the recreation room lacked a foundation, was not heated or could not be heated as represented, had a structurally deficient roof and ceiling, and that the wiring and construction did not conform to New Mexico Building Code requirements. Easton versus Strasburger, 152 3D 90 199 Cal RPT 383 Cal APP 1984. In this case, the court ruled that the broker had obligation to perform a reasonably competent and diligent inspection and disclose to buyer what was revealed by that inspection. In Easton, the plaintiff purchased a house that was later severely damaged by a landslide. Both the seller and listing agent had been aware of past earth movement and had failed to disclose this to the buyer. Note, Easton versus Strasburger was the first case to impose a duty on the seller's agent to disclose defects to the buyer, even though no fiduciary relationship existed between the seller's agent and the buyer. Licensee has duty to buyer to identify correctly the property for sale. Tri Professional Realty Incorporated versus Hillenberg, 669 Northeast 2D 1064 INDCT APP 1996. The Court of Appeals of Indiana recently decided a case concerning a real estate broker's misrepresentation as to the parcel of property that was for sale. The seller had put a for sale sign on the front lot but owned another lot in the subdivision. The buyer purchased the lot, but later it was determined that the seller did not own that lot. The purchaser began clearing the lot when she was confronted by the real owners. She then sued Tri Professional Realty for negligent formation of the contract, rescission of contract, and breach of warranty. The trial court found for the purchaser and ordered Tri Professional to pay her the contract price plus interest, taxes, and fees upon receipt of which she was to give a deed to the back lot to Tri Professional. The decision was upheld on appeal, and the court stated that real estate licensees have a professional duty to identify correctly the property they claim to have the authority to sell.